Hey y'all, welcome to the first episode of Supreme Court Docket Explained. I'm Nate and I'm your host of this web series. I'm starting this web series because I want to have a discussion of the cases on the current United States Supreme Court docket in a way that's non-legalese and in plain terms that everybody can understand. Oftentimes when you're discussing these Supreme Court cases in the media or with other people, they either don't really understand the legal issues being discussed or the legal issues in these cases are politicized, and a lot of people are missing what the actual legal discussion is about and what issues the court is actually considering in these cases. So what I want to do is have that discussion with you and cut through all the noise and really get to what is the court being asked to consider and what are the underlying facts that support the arguments on either side. A little bit about me. I am a licensed attorney. I've been practicing law for over 10 years, and I practice mainly in the areas of corporate transactions and corporate law, but I do have a nerdy side, and I love reading the Supreme Court cases as they come down the docket. So I decided, hey, why not share that with people and help them out and get a better understanding of the facts in these cases? And so my inspiration for this series. So what I really want to do with you is for each case that we discuss in each episode of this series, I want to kind of take you through the underlying facts and the procedural history of the case and how it got to the Supreme Court. And then once it's there, okay, what are the points of law that the court is then being asked to consider in these cases? And then I'll take you through the facts and analysis of each side of the case and kind of give you the arguments and the reasoning behind why they think the court should rule one way or the other in these cases. And then for fun, I can make my prediction and how I think the court's going to rule in each of these major cases. But of course, my opinion doesn't matter, does it? It's only those of the Supreme Court justices. A little bit about the court, for those of you who don't know, it's made up of 9 justices that are appointed by the then sitting president. And those nominees are ratified by the Senate. And once they're ratified by the Senate, then they can serve on the court in accordance with the Constitution. There are currently 12 circuits within the United States in the federal court system, and that includes the DC Circuit Court of Appeals. And within each of those circuits, there's a bunch of district courts. So the district court level, that's where the trials happen. So that's where you have a jury rendering a verdict or a judge issuing a ruling. And then if the parties are unsatisfied with that ruling and feel that there's been an error in the application of the law at the district court level, then they can go apply for relief to the appeals court or to the Supreme Court. The Supreme Court only considers questions of law, and it does not consider questions of fact. So to explain what that means, in simple terms, the Supreme Court is not going to hear whether or not there's enough evidence to convict someone of murder. That's left to the district court and the trial court. But, however, the Supreme Court would hear an issue as to whether a defendant's Fourth Amendment rights were violated in the collection of evidence in a murder trial. So if that was the case, if the lower court misapplied the law concerning search and seizure under the Fourth Amendment, then they may overturn the case and remand it for a new trial if they deemed it necessary. So to summarize, essentially the court's going to hear whether or not the lower court applied law correctly in each case, but it would not make a decision as to whether or not the lower court or the jury decided that there was enough evidence to convict someone of murder or not. That's left up to a jury or the judge, in that case, if it's a bench trial, to decide whether or not there's enough evidence to support the conviction under the laws as it's applied in the case. To get your case in front of the Supreme Court, you have to file a petition for the writ of certiorari. For that petition to be granted, you have to have at least 4 justices on the court say that they want to grant the petition and hear the case. If 4 justices decide that they do not want to, then the case will not be heard by the United States Supreme Court, and the judgment of the lower court of appeals or the district court will stand. If the court does grant certiorari, then the United States Supreme Court will hear the case. In this series, we're going to mainly be discussing 2 types of cases that the Supreme Court is going to be hearing. There's others, but the major 2 are, 1, when there is a division in the circuits. So the Ninth Circuit Court of Appeals out west may come down on a legal issue differently than the 11th Circuit here where Atlanta is. So that's an issue when one part of the country is applying law in one way and then another part of the country is saying, no, this is how it should be. The other area would be where the lower court has misapplied federal or constitutional law with respect to a case. So finally, no discussion of any legal topics would be complete without a disclaimer by the attorney, of course, for liability purposes. So just want to remind you that this web series is not intended to constitute any legal advice, and that if you have any issues, you should consult your own attorney. And this series is only for general informational purposes and should not be used as legal advice of any sort. The views and opinions expressed by me, if any, during this web series are my own, and they are not the views or opinions of my employer or any other third party for that matter. So thank you for your time. I look forward to the discussion with you on this web series, and the first episode will be up soon. Thanks. Y'all have a good one, and I'll talk to you soon. Bye.